Today we are looking at 20 questions on liability for property disclosure. Good luck. Which of the following is typically required in a property disclosure form? A, the property's market value. B, known defects or issues with the property. C, the seller's reason for moving. D, the buyer's financing details. B, known defects or issues with the property. Sellers are legally required to disclose known defects to avoid liability for failing to inform the buyer about property conditions. The seller knowingly conceals a major defect in the foundation of their home. Who is primarily liable for this non-disclosure? A, the buyer's agent. B, the seller. C, the appraiser. D, the title company. B, the seller. The seller is responsible for disclosing material facts about the property. Concealing defects can result in legal liability. If a real estate agent is aware of material defect but does not disclose it to the buyer, who can be held liable? A, only the seller. B, only the agent. C, both the agent and the seller. D, no one. C, both the agent and the seller. Both the seller and the agent can be held liable for failing to disclose material defects known to them. Which of the following is not considered a material fact that must be disclosed to buyers? A, structural damage to the property. B, previous pest infestation. C, the seller's divorce. D, known environmental hazards. C, the seller's divorce. Personal issues such as the seller's divorce are not considered material facts affecting the property's value or desirability. What is the primary purpose of property disclosures? A, to help sellers avoid paying for repairs. B, to comply with mortgage lender requirements. C, to inform buyers about the property's condition. D, to negotiate lower commissions for agents. C, to inform buyers about the property's condition. Property disclosures aim to ensure that buyers are aware of any issues that may affect the property's value or usability. Before we move on, please take the time to subscribe. Many of the people that listen to this channel have never subscribed. It really helps us in the algorithm. Also, hit the notification button. It's free. It helps us to get the content out so more people can pass the real estate exam. So also, if you like this content, please hit that like button. I appreciate it. Thank you. Who determines what must be disclosed in a real estate transaction? A, federal law only. B, state and local laws. C, the buyer's preferences. D, the seller's real estate agent. B, state and local laws. Disclosure requirements are governed by state and local laws which specify what must be disclosed in real estate transactions. If a property is located in a flood zone, who is responsible for disclosing this to the buyer? A, the buyer's agent. B, the appraiser. C, the seller. D, the home inspector. C. The seller. Sellers must disclose known risk, including whether the property is in a flood zone, as it can affect the property's value and insurability. A seller completes a property disclosure form but intentionally omits information about a leaky roof. What legal consequence could the seller face? A. No consequences if the buyer does not find out. B. A fine by the real estate commission. C. Lawsuits for misrepresentation or fraud. D. Denial of the sale. C. Lawsuits for misrepresentation or fraud. Intentionally omitting material defects can result in legal action for misrepresentation or fraud. In most states, property disclosures are required to be given to the buyers. A. After closing. B. During the inspection period. C. Before a purchase agreement is signed. D. At the buyer's request. C. Before a purchase agreement is signed. Disclosures are typically required before the buyer enters into a binding contract to ensure informed decision making. Which of the following would most likely be considered a latent defect? A. A cracked window. B. A leaking roof. C. Termite damage hidden within the walls. D. A broken door lock. C. Termite damage hidden within the walls. Latent defects are not readily visible or discoverable by normal inspection, such as termite damage within the walls. What is the liability of a real estate agent who unknowingly fails to disclose a material defect? A. They are automatically liable for negligence. B. They may not be held liable if they were unaware. C. They are liable regardless of knowledge. D. Liability depends on the buyer's inspection report. B. They may not be held liable if they were unaware. Agents are generally not held liable for undisclosed defects that they genuinely did not know about. Which of the following must be disclosed under the Residential Lead-Based Paint Hazard Reduction Act? A. Lead paint in properties built after 1978. B. Lead paint in properties built before 1978. C. The presence of asbestos installation. D. The presence of radon gas. B. Lead paint in properties built before 1978. Federal law requires disclosure of lead-based paint hazards in properties constructed before 1978. A real estate agent discovers mold in a basement during a showing. Was it their responsibility? What is their responsibility? A. Ignore it, as it is the buyer's responsibility to inspect. B. Disclose the mold to the buyer immediately. C. Inform the seller but not the buyer. D. Recommend professional testing but avoid disclosure. B. Disclose the mold to the buyer immediately. Real estate agents have a duty to disclose known material defects, including mold, to all parties. A seller claims they are unaware of any defects but knowingly hides water damage. This is an example of A. Fraudulent misrepresentation. B. Negligence. C. Honest mistake. D, innocent misrepresentation. A, fraudulent misrepresentation. Intentionally hiding a known defect is fraudulent misrepresentation which carries legal consequences. In most states, does the seller have to disclose a death that occurred on the property? A, yes, in all circumstances. B, only if the death was violent or stigmatized. C, no. Deaths are never required to be disclosed. D, only if the buyer requests this information. B, only if the death was violent or stigmatizing. Disclosure laws for deaths vary, but many states require disclosure only if the death was stigmatizing, such as a murder. Before we move on, once again, I'd ask you to please subscribe. Many of you watch our content and find it helpful, but many of you have not subscribed. It doesn't cost you a thing. It's free. And if you subscribe, you won't miss a video if you hit the notification button. It's free to do so. Also, if you like this content, please hit that like button. It really, really helps us out. It helps more people pass their real estate exam. Thanks. Which party is responsible for verifying the accuracy of the property disclosure form? A, the buyer. B, the seller. C, the seller's agent. D, the home inspector. B, the seller. The seller is responsible for accurately completing the disclosure form based on their knowledge of the property. The buyer moves in and discovers issues not disclosed on the form. What should they do first? A, file a lawsuit immediately. B, request mediation or arbitration. C, contact the seller to resolve the issue. D, ignore the problem. C, contact the seller to resolve the issue. Buyers should first address the issue with the seller, as it may be resolved without litigation. In a caveat emptor, buyer beware state, what is the seller's disclosure obligation? A, full disclosure of all defects. B, only latent defects must be disclosed. C, no disclosure is required. D, disclosure depends on the buyer's request. The only latent defects must be disclosed. And caveat emptor states sellers are typically required to disclose only defects that are not obvious or discoverable. What must the seller disclose about an HOA, homeowners association? A, the names of all HOA board members. B, HOA rules, regulations, and fees. C, the seller's relationship with the HOA. D, planned maintenance projects for other properties. B, HOA rules, regulations, and fees. Sellers must provide information about HOA obligations, including fees and governing rules, as these impact the buyer. When is a property disclosure form typically not required? A, in a foreclosure sale. B, the property sold by the owner without an agent. C, when selling to a family member. D, for new construction homes. in a foreclosure sale. Properties sold in foreclosure are often exempt from standard disclosure requirements, as the lender may not have knowledge of the property's condition. Well, I hope you did well. Once again, please take the time to subscribe and hit that notification button so you don't miss a video. It is free to do so. Also, click the like button now if you enjoy this type of content. Thanks. It really helps us out. Have a great day. Today we are looking at 20 questions on liability for property disclosure.